Last week, the Kentucky Supreme Court struck down the city of Louisville minimum wage ordinance, saying the city didn't have authority to set a separate minimum wage. And even if you're not in Kentucky or Louisville, this is an important case, part of a trend where more and more labor and employment issues are dealt with at a state and local level, particularly wage and hour being one of the main areas where that's the case. So what does this mean for employers? Three things. Number one, certainly you need to be aware of what's going on in the various areas where you do business. Even a smaller company that may be relatively local. In Columbus, for example, there's a sexual orientation discrimination ordinance. There is not in surrounding communities. So different employees are potentially subject to different rules. So you just need to be aware of that. Number two, businesses may want to advocate at a state and local level in a way that they maybe feel they can't sometimes at the larger federal level. And number three, on a nuts and bolts practical level, you really need to think about how this affects your policies. There are different ways to address the fact that different employees are subject to different laws. There may be sort of catch-all, as provided by applicable law kind of language you can use. You may need supplements for particular states or municipalities. You may draft a policy that simply complies with whatever the most demanding rules are. And so we have to take these one by one, but this is a trend that will continue, and employers need to be aware of it and respond to it.